Okay, so what we're doing today is we are going to look at some of the exercises we've done already together and then apply the formalities down onto there. So hopefully you'll have seen in the previous lecture or supplement the 4-box method that I like to use. It's something I've developed myself for ease of mapping across from the moment of estate interest, law, equity, into what we're about to do now of putting the right document on it, and then where we're headed next in terms of registration. So you've got that format or that structure there to be used and to be relied upon. So if I could invite you to have access to that document through any of these early lectures, and you will then kind of need to grasp it for moving forwards. That's the foundation upon which we're building after this, so it's incredibly important as a model. It will provide a lot of structure for you. So that's something to aid and assist you that I've devised that I think will make sense of it. Hopefully it's not too terrifying, but it's something we will be working through in seminars as well to make sense of it. So I want to look at formalities as applied to the previous exercise, then thinking about the fact that land has been heavily legislated for in the UK. In 1925 we have a raft of property related statutes, and we as land lawyers need to be at ease with that. It's what we rely on heavily, and you'll have seen that already. We're citing the LPA all the time. And again, that's something in seminars we're going to have to get used to, because literally every sentence, every few sentences in land law will be cited. And that's why I've encouraged you to become comfortable with the statutes from the get-go. We have to be familiar with what they are, how they work, what they do, and most importantly, we've got to cite and reference them constantly throughout our work, because that is where the law relating to land comes from. And hopefully, as you realise, land being different to any other form of property means that the impact of it is huge. We're attaching and affixing to the thing itself, the land, so we need to ensure that we've met the statutory requirements for that attachment. Okay, so looking at where we were previously in terms of Ali's ownership of the freehold, the fee simple, absolute and possession, we recognise this as being legal under section 11A of the Law of Property Act 1925. We had Brenda with a leasehold, a term of years absolute, hopefully now recognising that that is also capable of being legal under section 11B of the Law of Property Act 1925. We had various forms of interests. We had a beneficial interest, payment into the property that could only ever be equitable because it didn't fall within section 11, didn't fall within section 12, so it meant it had to be equitable. We had an easement that was capable of being legal under section 12A if it was freely given or it was time fixed. If it was going to be any looser than that, it could not be legal and it could potentially be equitable instead. Dealing with a restrictive covenant not to run the property as a business would only ever be capable of being equitable. Again, not listed in section 11, not listed in section 12, so having to be equitable under section 13. The bank with their mortgage is listed under section 12C and therefore will definitely be legal. It's a legal interest, however, in this case, and not a legal estate. So we've already looked at those previously. We've recognised which estates there are, 2, which interests there are, many, and the fact that they're only capable of being 2 legal estates and 5 legal interests. Everything else being for equity. Also, not forgetting that Ali, as the landlord, as the fee simple absolute and possession holder who has created this tenancy, develops her own rights within the ability to retain her land and enter it. So she would also have a legal right of entry, section 1(2)(e). So now we've recognised the estates and interests and law and equity aspect of that in the previous lecture 4. We're looking at then formalising or documenting that, because we would need the right documentation as land lawyers. We're thinking as land lawyers of the need for a piece of paper. We're evidencing that hold or that affixation, attachment to land in a higher way. So section 52 of the Law of Property Act 1925 says that where we're creating or we're passing from one party to another any legal estate, so ownership or tenancy, or a legal interest, the two bank ones, the two pertaining to kind of rent charge and right of entry and easement, all of those would require a deed in order to then make them legal. If there is no deed, we still, as land lawyers, would require and expect to see some form of writing. We would expect to see a contract under Section 2 of the Law of Property Miscellaneous Provisions Act 1989. The exceptions obviously being for a short-term lease under Section 54(2) for the need for a deed. And we'll look at the exception for a contract again in a moment. So ultimately, every time we're seeing legal estate 2 or legal interest, the 5 under Section 1(2), then we are needing a deed in order to make it so. For equity under Section 53, we're still writing it down. We're still requiring some form of writing for the interest to be created in the first place, or transferred or disposed of in terms of passing it elsewhere. Our only exception being, as we've discussed previously, for these situations where people wouldn't behave in that way, so less formal situations will come to that exception. So the idea again is that the form of that substance is that it's written down, there's a signature, and there are terms of that contract, that it's quite clearly written and with specificity of term. If it's relating to a piece of land, that there is clarity as to the extent and scope of that, etc. So that's under Section 2 of the Law of Property Miscellaneous Provisions Act 1989. So just to sum up again, where you've got 2 legal estates and 5 legal interests, under Section 52 we would need a deed in order to actually make those legal. Under Section 1(3), everything else being equitable, we would require that to be disposed of in writing. The exception again being Section 53(1)(b), where there is a beneficial interest under a trust. So the exception to the need for the deed would be a short-term lease. The exception for a need for writing under contract would be a typical kind of cohabitation, familial, domestic situation where one party has a relationship with the other and has put investment into the property as a result. Okay, so then it's important really for us to ensure that we know and understand what that means for our parties that are involved, because we as land lawyers are now going to be doing the hard work of trying to find that documentation. So Ali's ownership under the fee simple absolute and possession of Section 1(1)(a) of the Law of Property Act, in order to be legal and in order to be enforceable and to make her the true owner, she would have to have had that documented by deed under Section 52 of the Law of Property Act. Again, we don't know the scope or extent. I think it was 10 years actually in the previous slides. but we'd have to look at the scope of any lease. But a lease in itself is capable of being legal under Section 11B. Hopefully your mind is starting to run with the fact that we would then look at the extent or scope of the lease as to the time element on that, knowing that if it's under 3 years, we don't actually need a deed. So we've got these things called parole leases, which allow for a shorter term recognition of a tenancy. Otherwise, with every time we had a tenancy situation, for every lease, requiring the documentation to be a deed would be cumbersome, would be expensive, and would make the system very slow and archaic. So we have to be able to allow for these shorter term relationships with land without a deed, but also recognising that as a holding land, they're very important. The tenant is the next in line, really, if you're thinking about it as a hierarchy below the owner. So their hold in the land is incredibly important. That's why it's a legal estate. So those two legal estates, in order to become legal, would need a deed unless that lease was under 3 years. Interest-wise, Yvonne has a beneficial interest. We have already considered the fact that it can only be equitable under Section 1.3. It's not in 1.1, it's not in 1.2. Therefore, because it can only be equitable, we can't put a deed on it and make it legal. That's not how it works. It's only ever capable of being equitable. So the right document, if we are to document it, would be to put a contract on it. We're going to do more work on that together when we come to registration as well, but it's important for you to recognise that that's not really how these relationships work out. In this situation, we have a parent gifting to a child, and in a lot of these cases, we have partners contributing to a family home. So in those scenarios, whether it's actually, Yvonne's probably not a gift, it's an investment in the property because she's living there as well. So we have these situations where there's an element of kindness, there's an element of support, but there is also a benefit going across to that party too, whether that's the fact that they live there or they have some sort of hold in it. It's in their interest too. So literally they have a benefit in it and it's in their interest, a beneficial interest in the property. So in that situation, we as land lawyers ideally would look for a piece of paper. We want that stuff to be written down. It would make our lives very easy. However, under Section 53(1)(b), there's a recognition in the Law of Property Act that that's not how life goes and that these people probably haven't behaved that way. So there is an exception for an implied trust not to require writing. So that's quite important and something we will come back to again. Karen's easement. So again, we looked at the fact that it was capable of being legal under Section 1.2a if it looked like it was freely given and or it was given for a fixed period of time, 6 years, 10 months, whatever it might be. That, in order to be a legal easement, would need to have been protected with a deed. It should have had a deed documenting its existence. Again, that document would evidence the scope of the easement, the piece of land it pertained to, who benefited, etc. If, however, that easement had not been capable of being legal, so it wasn't freely given or for a fixed period of time, it could be equitable and then it would need a contract instead. So we're still looking for a piece of writing around this easement, but we're not requiring it to be a deed if it's not legal. The other situation could be that under Section 1.2a it was capable of being legal, but there was no deed and therefore it doesn't become legal. But if it's written down in some other form, it will become an equitable easement. Again, nothing to labour over too much at this stage. It's one of the elements of the seminar, and we'll be coming together to look at it in more detail and discuss it together. Dillon has a restrictive covenant, so that covenant to stop it being used for business purposes can only ever be equitable under section 1.3, and therefore evidentiary requirement for that as a piece of writing, we would need a contract. And the contract again would stipulate exactly what the elements are of that restriction, who benefits, etc. The bank having a mortgage, again knowing that any legal estate or interest, in order to remain so or to become so, has to be created through a deed. And then finally, even Ali's landlord's right of entry as a legally enforceable interest, it should have been protected by deed. So that's the document that we would require as landlords as evidence that that estate or interest is validly protected. Okay, so hopefully you can see that we're building. This is the foundation upon which we are continually building. We had to recognise whether something was an estate or interest in the first instance. We then had to recognise that box 1 stuff on the 4-box approach to land law. So box 1 is that darker blue stuff. What is it that they've got as an estate or interest? Then you've got the next box across, if you've got that 4 boxes in front of you, the next box across being, is it legal or equitable? Under what piece of legislation might it be so? Section 1.1, the 2 legal estates in the light blue, and section 1.2, the 5 legal interests, again in light blue, and then everything else being section 1.3 has to be an equitable interest. So box 1, estates and interests, box 2, law and equity, box 3, what evidentiary requirement do we need? What piece of paper will make it so? And here again we're seeing in red us laying another level on this foundation that we're building. So we are laying down the documentary evidence, knowing that all legal estates and interests require a deed, our only exception being a short-term lease. All equitable interests requiring a contract, again our only exception being that of an implied trust. Okay, so that is the solid stuff that we need to grasp and that I'll be working through with you together in class. And please come armed with as many questions about that stuff as you can, because that's the stuff that I really need you to know how to do and how to play with moving forwards, because that's the kind of baseline that we're working from. Okay, so where we're about to go now is to look at how we've ended up where we are through the legislation. So how has it been that we as land lawyers have so much statutory evidence and provision to work with? And that's really because in 1925 property law had a moment, and there was an absolute gamut of land law and property law statute put in place. We're going to focus on the 3 most important and relevant pieces of land law, but there were other aspects too, like the Settled Trusts Act, etc. So we have a lot of property legislation coming about, pardon me, in 1925, some of which has been updated and revised, and I need you to relate to the new legislation, not the 1925 one. The point of all of this at the moment is just to make you see what a seminal year that was for land law, and that they really wanted to address many issues pertaining to holding and transferring land. So the key one that we've been working with to date has been the Law of Property Act 1925, and that's our core. It's usually what we are using as a go-to to recognise these key elements of estates and interests, etc. So I'm going to look through each of these statutes with you and see how they fit together with what it is that we're about to do, how you use them to best advise your client. The Land Charges Act was in place to deal with unregistered land, so there would be an articulation for procedure as to how land could be recognised and transferred, and people could protect interests in it were the land to remain unregistered, because they knew that everybody wouldn't go straight out on the 1st of January 1926 and register their land. That has been updated and amended and is now the Land Charges Act 1972. So if you were referencing that act, that is the act that you would use. And then finally, and quite important for where we're about to head, we have the Land Registration Act 1925. So the creation and establishment of a registry for land and some form of documentation and formalisation of who had what regarding land that would be held centrally at Land Registry. And that obviously has been updated and replaced by what we now recognise as the Land Registration Act 2002, and that will be the act that we reference and cite in our work. But it's important for you to know that this all happened in the same year. How we could recognise and refer to land, how people could attach and affix to the land under the old system, and a new system for land registration that would allow people to appear on a register for the world at large to see that they existed. So before that, before we had such a systemised approach to all of this, it was very difficult. I mean, one of the discussion groups I'm going to launch this week is about the idea of detective work, of like how much research needs to go into a conveyance. How much detective work do you think a conveyancer has to conduct or perform whenever it is that they're looking at transferring a property from one party to another? What do they have to find out? Where do they go? How does it work? But previously, before land registry, all of that was completely chaotic. So before the Law of Property Act 1925, there were all these different types of estates and interests. There was a lack of clarity as to who held what the meaning of that was, how it attached and affixed to the land necessarily, and how you could transfer land in the presence of all of that confusion. So the Law of Property Act 1925's intent and purpose was to clarify that, to tidy it up, to make sure that it was very clear and articulate what estates and interests there were and how they affixed and attached and how to transfer them. Conveyancing itself, in order to pass land, was what can happen in a lot of areas of law, the 3 C's. It was very complex, it was very expensive or costly, and it was very cumbersome. It was a very difficult thing to do. So it made the process of transferring a property a really big deal and something you had to be very invested in and determined to do. Bearing in mind that there would have been fewer property owners then, and a lot of property would have been held by far fewer people. There would have been many more old-fashioned ways of holding land and fewer people with the power and finances to own their own property. So that meant that conveyancing was a bit of a privilege. If you had property to transfer, you were seen to have money to allow for that to happen. And there had to be, in a more modern democratic society where property ownership was the norm rather than the ideal, a simpler way to pass property from one party to another. As well as that, it was much more difficult to borrow money against a property's interest. So the recognition of a mortgage was less certain. There wasn't as much protection for banks or lenders prior to this 1925 legislation. And again, if you're thinking about the ability for people to become property owners as norm, then you're going to have to allow them some way of funding and financing that. And banks won't lend to people without some idea of a security against the asset and a protection if it goes wrong. So while I've put trusts there first, actually the idea in most situations behind the gamut of legislation that comes in 1925 is very heavily focused towards property as an asset and protecting that asset, and definitely protecting that asset where one of the parties involved is a bank. So there is an idea around protecting trusts, and there was even some trust legislations put in place in 1925. But again, it's not necessarily to say that the beneficiary is protected against all others, especially where that other is a bank. It just puts in mechanisms, and we will look at some of those mechanisms. There's a thing called overreaching that we need to look at. It allows for a recognition of the beneficiary, but it also allows them to be taken out financially by payment of their interest to other parties. So that's again a benefit that it's recognized, but then it's kind of nullified as recognition if there's a way to overcome it, and or the phrase is called overreach it. However, you've got again this still hierarchic approach to land, and you'll have seen that in what we're doing already, this idea of state ownership, the hold of the bank, this recognition of the balance between landowner and tenant and all these other people. So there is still a kind of feudal approach that it's impossible to completely do away with. It's impossible to do away with crown rights to land. So the notions and the constructs that have been put in place, like estates, the fact that we can't call someone an owner, we have to call somebody a fee simple, absolute, and possession holder, means that a lot of this is constructed to navigate the fact that the crown still holds all of the land, and that our relationship to it is having to be artificed somehow by this legislation. So all the terminology, all the constructs, all the ways of looking at land are found within those statutes, which are trying to navigate and work around the fact that this feudal model is intrinsically still there. So the purpose of all of this legislation was to provide clarity, but hopefully, as you'll already have seen, and as lawyers more generally, sometimes the reliance on legalese and jargon and Latin phraseology is making life very difficult for us. You know, I can tell you that land means real things and also relationships. That as land lawyers, they both attach to the land, the real things themselves and the relationships in land. But it's not particularly helpful when I look at Section 205 of the LPA and start talking about corporeal hereditaments and incorporeal hereditaments. That is not clear. So there is a way to go still in terms of developing that clarity in land law, but we have a system at least to work with and a framework that I can translate for you. It's there at least to be translated. So we have a structure. Some of that structure comes from the Law of Property Act 1925. Don't know why that's in different sizes, sorry. As you'll have seen, we already know what land is and how it's composed, what it's made up of. So those structures of estates and interests, those constructs, things that have been effectively made up to navigate crown ownership, are there within the LPA. We know what land is, so the physical aspects and the relational aspects too, and what those look like in terms of section 1.1, section 1.2, section 1.3, blah blah blah. All of those previous estates and interests, the fee tail, life estate, etc., are reduced and or made equitable, because they just become that everything else. Whatever else it is everything else, and then we'll need a piece of paper to tell us what the everything else is, because an equitable interest requires a contract. So as land lawyers, we developed this system. We now have this system where we've got 2 estates, 5 legal interests. They require a deed. Everything else becomes equitable. That requires a contract, and there's only a couple of major exceptions to that: a short-term lease and a beneficial interest. Again, it looks at that role of law and equity. So it says we're needing these types of more formal and solid documentary requirements where there's a legal estate or interest at the heart of it. Not to say that equitable don't matter, but equitable interests will then just have a different evidentiary requirement, because they are more fluid, they are more personal, they will be promissory between 2 parties. When we looked at those things like covenants, estate contracts, beneficial interests, there are conversations between parties as to behaviours. So that stuff has to be equitable. It prescribes then our administrative task when it comes to that, how we should behave. So what documentary evidence are we looking for the parties to have filled in order to state that that's what they have. It allows for what we recognise as a trust, so we're finally seeing a trust written into property statute, but by putting it as a trust for sale, effectively you're diminishing it as a trust of land, because a trust of land would attach and affix it to the land. A trust for sale becomes something that can be bought, and that's where you get this notion of overreaching, that I can buy out my beneficiary because their trust is for sale. I can buy it out by giving their money in the property over to 2 people, and that's is a protective mechanism, but also detaches them from the land. So it's quite interesting that the LPA on one hand gives and in the other hand takes when it comes to protecting these trustee beneficiary relationships and recognising that they could be subject to abuse. So we'll be looking into that in more depth at a later stage. The Land Charges Act I'm going to run through very briefly, because we won't be looking at unregistered land within this course. It allows for the protection of equitable interests in unregistered land. So there's a class system where people can enter charges to say that they have those equitable interests. They have a beneficial interest under a trust, they have an estate contract, they have an equitable easement, they have an equitable mortgage, they have equitable interests in land that has not been registered yet. So those people can still enter themselves down onto a document that shows that they exist, but it's a land charge rather than a registration. It's there to protect people who are buying and people who are lending, who will be able to still find or see these people somewhere, although it won't appear at land registry. It creates a different form of register. It creates a collection of these people who have charges. If you want to refer to that as a register, that's up to you. I prefer to avoid that language because it can lead to confusion then when it comes to registered land. But yes, ultimately all these people will appear somewhere as a collected set of charges that appear, and it acts as a form of notice to anyone coming along to the land who will have to look at them and see that they exist. The classes are broken down. There's class A to F, and you enter your type of protection against the classification that you have. So as I say, I'm not going to go into that in any great depth because that's unregistered land, and we are going to focus primarily on registered land, so you don't need to learn this. There was an understanding that everybody wouldn't go out, on the 1st of January 1926, once land registry had been set up and registered their land, that land would become registered in key moments, but there still are small pockets of unregistered land in the UK. And it's important for your own knowledge, and some of the textbooks deal with this situation where people could protect themselves by appearing as a charge. We're, however, going to focus on registered land itself. So the Land Registration Act 2002, created in 1925 and amended and updated more recently, allows for people to put themselves on a register. All land in the UK ideally becoming registered, and us being able to have a visual representation of all the land in the UK at a glance, and then for parties who are purchasing it to be able to see it, to go to a document that evidences who has what and what the land is encumbered by. So it's a protective mechanism for the people who have those interests. It's in their, obviously, interest to put themselves on the register so that anyone who comes along to the land can see that they are there. There is a compulsory registering process. So if land was previously unregistered and it was sold, that would become what's called a trigger event, and that trigger would create the need to go and register that piece of land at land registry. So anytime unregistered land has been sold, that has acted as a trigger event, of which there are a number of trigger events that will lead to land having to become registered. So the person with the interest then adds themselves onto the register. As we've already identified, it's in their interest to do that, so they're the ones that has to protect themselves in that way. Therefore, the person coming along to buy or the bank who are going to lend money are lending with or buying with full knowledge. They can see the land, they can see who's going to be encumbering it or restricting it. A lender can know whether there's a covenant attached to it, restricting its use and therefore its value. Same, a purchaser can buy it knowing that there's an easement on it and somebody will be wandering or wombling across the back of the property and they will be encumbered by them. But there are other situations where people don't always appear on the register. It's known as the crack in the mirror. We'll look at the mirror principle in a minute. The idea being that the mirror should reflect back what the land is doing. So you should be able to look at the register like you'd look in the mirror, see yourself reflected back. There are, however, moments where people don't have to appear, because if every time we had a short-term situation on land, we had to go to land registry, again the system would become encumbered and just too difficult. So we still have an amount of detective work to do as conveyancers. We still do need to ask the questions of the person who is selling the land. So the ideal behind the register is that the purchaser should be able, the person coming along to buy land should easily be able to discover who owns the land. So we should be able to see the freeholder, the fee simple, absolute and possession holder from the get-go as the true party who can transfer the estate across. What does it come with as a benefit? Are there easements over other land? Are there some forms of enjoyment that I get with the land? So are there benefits that come with it? What do I enjoy with it? Do I get a sitting tenant that generates an income? What is it that I get with it? Does that mean then that those other people have rights over my land? So I benefit from getting rent from somebody, but that means obviously I have a tenant who has the absolute right to exclude me and treat it like their own, subject to the terms of the lease, obviously. All of that should be evident when we go to land registry. Should be able to go to land registry and see all of this on the documentation that exists there. Should be able to articulate who the true owner is, who has any other attachments to the land, and or what do I get with the land itself. So the register is established with 3 key principles at the core of it. The first one I've already discussed, the idea of a mirror principle, quite simplistic view of a reflection. So the idea that what I see is what I get. I should go to land registry. There will be a map, so there will be a very visible representation of the plan. I can see the boundaries. I can see the relationships either side, etc. So there will be that physical aspect to it, but also then I can look at a reflection of who has what pertaining to the land. I should be able to see those rights listed in the land. So that's the mirror principle. The idea that I look at the register and it reflects back at me the truth of the land. Again, knowing that we'll be talking about times where there's a crack in the mirror. There are these moments where these people don't appear on the register, either because they can't or they didn't have to, and we still need to find out about them. So the detective work continues. Insurance principle is another key aspect of land registration. This idea that the register is protected and guaranteed by land registry. So the title is state guaranteed as being truthful and verified by the state, and therefore that if there's been any mistake, that there will be indemnity and it will be the state that is responsible and payment will be provided, so that it's possible then for the rectification of the register will be made right, it will be corrected, and the parties will be recompensed for any losses. So that insurance principle is the state guarantee to the new purchaser or the lender that they will hold an accurate representation of the land, and if there's any error on their part, they will fix it and put it right. The final principle that land registration is built on is the idea of the curtain principle. The curtain principle being that you are dealing with, if you're thinking about the curtain on a stage in the theatre, that you're only dealing with whoever's in front of the curtain, and that all the other actors and stagehands and makeup people or whoever are behind the curtain. You are only interacting with the people that you should be dealing with, and everybody else stays outside of the conversation. So I, as purchaser, will be dealing with the fee simple absolute and possession holder. They are the true owner. They are the party that I interact with. That's the conveyancing procedure from purchaser to vendor. Everyone else kind of stays out of it. So the curtain principle is that notion that I deal with whoever's in the front of the curtain, the fee simple absolute possession excuse me, holder that is evidenced on the register. So that person who appears at land registry as the true owner is the only person I'm going to deal with. I don't have to concern myself then with anyone else behind the curtain. Those beneficiaries, those banks, etc. It's for the person who is selling the land to free themselves of those parties. They have to free themselves of their beneficiaries. They have to free themselves of their mortgage and pay the bank back. I don't concern myself with that. Obviously, again, like the Kraken mirror, that has flaws, because if they aren't removed properly, I'm stuck with them. So there has to be a mechanism for their removal, and I have to ensure as the buyer that that process is being done, but I deal with it through the vendor. Again, we'll look at that in more detail together. But ultimately, what you're focusing on at the moment, where we're going to be looking at next, is this concept of registration. How do the people that we've already looked at, so the people we've looked at in that exercise, how do they put themselves on at land registry? Where do they appear? How do we protect them? How do we show them off to a new purchaser? How can the purchaser take free of them? All of that stuff is what we're about to do in the next two lectures together. Three lectures together, sorry. So we've got 3 more lectures covering land registry and fixing and attaching to land. Thank you very much.